the Joint Subcommittee to Study Mental Health and Services in the 21st Century, which will soon be, will it be the Commission on Mental Health, soon as of July 1st. The Workgroup 2 on Special Populations, I've been informed we have a quorum, so we will be able to proceed fully. We have several things on our agenda looking at a couple of bills that were referred by the 2021 session to the Joint Committee that we will be taking up, as well as looking at particularly forensic evaluation admissions and how that issue is playing out. With that, I'm going to save any other comments until we actually get to the subjects, and we'll turn now to our staff, Sarah Stanton, to go over the bills that were referred to the work group.
Good morning. This morning I'm going to talk very quickly about one pair of bills and then
before we start, do I have to ask for attendance in this situation?
Madam Chair, we can do a...
Yeah, well, I guess I do. Go right ahead, please.
Delegate Bell?
This is harder. We have to unmute. Yes, here. Thank you.
Delegate Price?
Here.
Delegate Ranson? Delegate Watts?
Present.
And we have Senator Deeds here as well.
Great. Thank you.
So, Madam Chair, you have a quorum.
Thank you so much, Michael. Sarah, please proceed.
Okay, so I'll start with the bills that were referred to us in 2021. It's a pair of bills. It's House Bill 2047, was Delegate Bourne's bill, and the companion bill, identical bill, Senate Bill 1315. This was Senator McClellan's bill. These bills deal with criminal proceedings and the consideration of mental condition, intellectual disability in those proceedings. The bills basically allow a defendant to introduce evidence at trial of their mental condition at the time of the alleged offense, including any expert testimony. If that evidence is relevant and it's not evidence concerning an ultimate issue of fact, it tends to show the defendant did or did not have the intent required for the offense charged and is otherwise admissible pursuant to general rules of evidence. That bill did include an enactment clause. Oh, one other important piece of that bill is that it provides that a court can issue an emergency custody order as well as a magistrate. So in a proceeding where a defendant may have offered that type of information regarding mental state, if the court finds that the person meets the criteria for an emergency custody order, the court could then issue an ECO. The bill also, in a third enactment clause, directs the Joint Subcommittee to study mental health services in the Commonwealth in the 21st century, that's us, to study and make recommendations about the appropriate standard of danger to self or others that should be applied to persons who are found not guilty under the provisions of this act. So a person who's found not guilty because they've introduced evidence of mental state that indicates they did not possess the required intent at the time the crime was committed. So we, over the course of this summer, need to determine what that appropriate standard would be and report back by, I'm sorry, let me flip to the right page, by December 1 of this year.
And if we can stop on that, and are there any questions? I have a couple of comments. Unfortunately, neither patron could be with us today due to conflicts. And so we will have a full presentation of this, I assume, the next meeting so that we can keep on schedule. I would also observe that I sat in on a CLE that was where Anna Mendez and I've forgotten the other gentleman were part of a presentation of how this legislation needs to be approached in presenting a case and what needs to be done in moving forward as far as establishing the required elements of this legislation as far as the effect on reasoning on the individual. I think that at our next meeting, perhaps a very brief presentation drawn from that CLE might also be informative as to how these cases are in fact being handled. I think that if I understood the situation properly, not being a lawyer or member of the bar, is that the bar is now required to have 2 CLEs in mental health. And so this is now being offered on this particular legislation as one of those CLEs available. Are there other questions or comments? And again, Delegate Bell, this really takes me back to your work following Virginia Tech on establishing just what is the standard. And this then gets into some of those elements of whether or not the standard ought to be different or not in dealing with people who have been adjudicated under this statute. Sarah?
Yep. Yes, Delegate Watts, we can look into that. And you are correct. The bill also, I didn't touch on this in the quick overview, but did establish some requirements around continuing education, those types of things. The other bill that's been referred to us was actually referred in 2020, but due to a number of issues last year, we were unable to add it to the work plan. This bill, Senate Bill 569, Senator Donovan's bill of 2020. The bill requires DBHDS to develop, or would have, it did not pass, would have required DBHDS to develop and obtain a mental health mobile application to facilitate the provision of crisis intervention services by licensed clinicians to individuals in the Commonwealth who access the app through calls, texts, online chat portals. Would have required that mobile application to be integrated with the crisis intervention phone hotline established as part of STEP Virginia. The bill also required would have required the Department of State Police, in coordination with the Virginia Fusion Intelligence Center, to develop or obtain a public safety mobile application to enable individuals in the Commonwealth to furnish confidential tips to the Department of State Police through text, audio, images, or video concerning suspected, anticipated, or completed criminal violations or school-related safety concerns. State police also would have been required to develop a referral system to ensure that confidential tips received through the application were referred to appropriate law enforcement agencies, school boards, threat assessment teams, or other relevant entities. This bill was passed by the Senate. It came over to the House and was continued to 2021 in the House Committee on Health, Welfare, and Institutions. It was not subsequently taken back up. So this bill did not become law, but the Health, Welfare, and Institutions Committee drafted a letter to the Deeds Commission, the Joint Subcommittee, requesting that they study the matters presented by the bill. So this is another bill that's been referred to our work group for study this year.
Are there questions? I will start off. Senator Deeds, are you on? My question is, as I read the impact statement, probably it didn't get through the House because it was a significant additional funding to what the governor had in his budget on part of the initiative, this 24/7 hotline. The reason why I put that context in is I am wondering if this initiative is being considered for American Rescue Act funds during the upcoming special session, since it so directly deals with the mental health crisis of school age population.
You know, that's not a bad idea. Well, I've kind of laid out some other priorities, at least in talking with the Department of Behavioral Health, that would center on finding ways to reward employees. You know, we've got a real crisis with our workforce, and we've got to find a way to raise pay. And so I've suggested that we come up with some one-time bonuses as a way for some of the employees, frontline employees who deal with folks who are ill, who have stuck with us throughout this pandemic. That I've asked the department and the CSBs to come up with some numbers about that. And I've asked the department to also look at capital needs, some one-time expenses. But this certainly, you know, ought to be considered. It's one of those things that would require an ongoing expenditure. And I've tried, at least in the priorities that I've developed for the special session, I've tried to think about things that would not require an ongoing expenditure, things that would be one-time monies or require one-time monies.
So if I can offer my voice to that, I would strongly suggest that there's an element of this that is startup, the 24/7 technical capability. And I have no hesitancy at all of making that investment in startup, knowing that we will have to have ongoing staffing because of, again, the mental health problems that we were aware of in our school age population, but which COVID's isolation, if not more elements of uncertainty, have really forwarded in so many of our youth. And this isn't going to go away in 1 year as far as those remnants of the effect of this year on the mental development of young people. So I would very much urge, since you're in the right place, that you to proceed with this element as well.
Well, maybe we just need to get a handle on what our upfront costs would be, and perhaps it's something we could try to look at. We've got $4.3 billion, and there are going to be a lot of people with a lot of ideas about how to spend that money. But there's no reason why we cannot make a lot of one-time investments in mental health. We're going to have 3 years to spend this money as well. So.
And I'm pretty sure there's a fiscal impact statement from last year.
Okay.
So there's good guidance on the breakout of cost on this.
Good deal. Okay.
Super.
Thank you.
Are there other comments, questions? Thank you. Sarah? Okay, so now our next element is an agenda item number 3 is the presentation of the jail diversion initiatives and forensic services. And I am so glad that I just saw Senator Mason join us. Hello, how are you, Monty? And he had surfaced this issue in his region of the effect on Eastern State Hospital, as well as the Free Press's coverage of this. So with that, I'm glad to have your involvement and perspective on this. And Sarah, if we can start the presentation.
Yes, Delegate Watts, and Christine is here to present, and I believe Alex is here to run the presentation. Yep.
It's always helpful to have a technical person.
There we go. So we should be ready to go.
Right. Good morning. My name is Christine Shine. I am the Deputy Director of Forensic Services at DBHDS. Thank you for having me. I'm here to present on some jail diversion initiatives that we have in our office, as well as some considerations for our forensic population. So you can move. There we go, to the next slide. Thank you. So jail diversion initiatives strive to identify individuals with mental illness that are involved in the criminal justice system, to divert them away from the criminal justice system, and then to connect them to meaningful services and treatment. We have several diversion programs that operate across the sequential intercept model. We have CIT assessment sites at Intercept 1. We have post-booking diversion programs at Intercept 2, and then we have several programs, diversion programs at the re-entry level of Intercept 4 and our forensic discharge planning that operates at Intercept 4. So I will go into each of these in the next slides. In FY20, 3,484 individuals were screened and 1,636 individuals were enrolled in jail diversion and forensic discharge planning services. Those services included mental health treatment, medication, medical services, acquisition of benefits, employment, and education programs, temporary and permanent housing, and other basic needs. We have found some positive outcomes for our diversion programs. There's been a decrease in the utilization of emergency and crisis services and a decrease in psychiatric hospitalizations 180 days post-discharge from the program. There's been a significant increase in the utilization of outpatient services, including case management and intensive community treatment programs.
Madam Chair.
And
Yes, please.
I'm asking if you want us. I'm interrupting to ask you if you want us to interrupt. Not being funny. What would you prefer? That's an interesting. She has some interesting information there that I would appreciate even more information about. Do you want us to wait or stop as she goes? And I'll do whatever.
If our presenter has no objection, I would prefer, given the level, the step through and the level of detail, if we ask questions now. Is that all right with you?
yes, of course.
Please go ahead, Delegate.
Madam Chair, so this slide is really interesting, and if she has some more information, so there's a decrease in the utilization post-discharge. I would ask her, maybe you could just share, like, compared to what, meaning what are we using as our baseline? Because that is a very important and useful figure, and if it's that high, that would seem to be very important. If she could just maybe share with us what we're using as our baseline and what that number kind of includes and that kind of thing.
I can get more information, but basically the CSBs that receive grant funding submit data to us every quarter on their utilization, and they include data on the services that people are involved in and whether they have housing at the beginning of treatment or whether they have housing at the end of treatment. Similarly, what their psychiatric hospitalizations are before and after treatment. So that's where this data is coming from.
Madam Chair, could I ask a follow-up?
Yes, Delegate Bell.
When they say, I'm not sure, it's a math question. When they say 100% decrease in hospitalization, does that mean none of them needed it, or does it mean something different? I mean,
yes, that they're. I believe that would imply that those individuals did not require psychiatric hospitalization 180 days post-discharge.
Okay, that's great.
Which is very important in our utilization of hospital beds versus community treatment, which has been such a concern of the Joint Committee.
Thank you.
Thank you for highlighting that, Delegate Bell. Please proceed.
Okay. And 40% maintained linkage or became connected to outpatient services during their time in the program and maintained them all in the program.
And of course, that's the flip side of the coin. Increase in community services needing to be provided.
Yes, yes. Somehow the slide, Alex doesn't have the CIT assessment site information, but I can present on that nonetheless. So our CIT assessment sites and our CIT programs, CIT training is designed to enhance law enforcement's ability to deal with individuals that are involved in a mental health crisis. It's a specialized training for a subpopulation of law enforcement, and it is different than regular de-escalation training in that it provides specialized strategies for individuals that are experiencing a mental health crisis. There are 39 CIT programs across Virginia, and there are CIT assessment sites, which are a location to divert individuals that are experiencing a mental health crisis away from the criminal justice system to a more appropriate location that is not involved in a criminal justice setting for assessment. In 2013, we started with 3 pilot sites, and now we have 39 sites across the state. The average cost for a CIT assessment site is $320,000. That does vary, but that's the average. And then recently we convened a work group at the direction of the General Assembly to discuss expanding CIT assessment sites, and we recommended the expansion to at least 5 crisis receiving centers across the state. And these expanded services would include psychiatric services, medical services, increased case management services, and peer services in a 23-hour observation and stabilization model. And so that report went out last year, I believe. So that is one of the Intercept 1 programs, and then we'll go to mental health dockets. We'll get back to the slideshow.
Madam Chair,
Yes, Senator Mason.
may I ask one question, ma'am, about the CIT study that came out in October? You said you recommended expansion in 5 areas. Does that mean you have funded that at this point and approved grant requests? Because this is certainly something that I hope we're looking to some of these funds and we're getting ready to go back to spend to utilize. Have y'all acted on any of that?
No, we did not receive any additional funds. The report asked us to come up with a plan of what it would look like if these sites were expanded and what they would look like. We did have some additional funds that we were able to use to fund, partially fund 2 programs across the state that will need additional funding to be able to maintain it. But we're able to do 2 partially in Highlands and at New River Valley. And they'll be able to have their CIT assessment site co-located with a crisis stabilization unit and provide basic medical care and access to psychiatric services and those things, but they will require additional funds. We had some one-time money that we were able to give them to start them up, and some additional funding that we had for rural areas that we were able to give them to assist, but we would need additional money to fund to maintain their funding and then to fund the additional 3.
Thank you. Madam Chair, one follow-up?
Yes, please.
So I know in the Williamsburg one in particular, there's like a grant request out to DBHDS for about $300,000 that would include this 23-hour area and a couple of other positions. Do you know how many existing CITs have made grant requests like that? And therefore, how many are outstanding if you've only funded those 2 in Southwest? Thank you.
Excuse me. Yes, I believe we received approximately 15 applications when we put out the notification of funding. The 2 were approved in the rural areas, and then none in Region 5 were approved for full funding. None of them were ready to do this full model. So some of the applications we received were just requesting to expand the hours in which they provided services or to add an additional staff, but not really make it into this type of model where they're able to add psychiatric services and medical services and those types of things. But we did very partially fund 2 programs in Region 5 that were ready to take the next step, but admitted themselves they weren't ready, even if given the money to take it all the way to this level. And so we gave partial funding to Hampton Newport News and Colonial CSB to help them get to the next level. And then hopefully next time we have funding, they would be able to take it all the way to this level of operation.
Thank you. Please proceed.
Mental health dockets. So mental health dockets were developed in response to the overrepresentation of individuals with behavioral health issues in the criminal justice system. They seek to divert eligible defendants with a mental health disorder away from the criminal justice system and into a community-based program with oversight from the courts and behavioral health professionals. Currently, in FY21, DBHDS funds 4 behavioral dockets out of the 14 that are approved by the Supreme Court. In those 4 programs, we've enrolled 338 participants since FY15, and 52% of them have successfully completed the docket requirements. On the next slide is a list of all 14 of the dockets that are approved by the Supreme Court, including the 4 that DBHDS provides funding for, which are Arlington, Roanoke, Richmond, and Stanton.
Questions? Proceed.
Okay. And I think mental health dockets are an area that we can really look to expand in as we look at some of the issues that we've seen in the admissions to the hospitals and as a diversion effort. So I think mental health dockets are an area that we can explore more as well for expansion. I'll be shifting gears a little bit now from our diversion programs to some considerations.
Before we leave this, the 40% of state mental health hospital census, is this concentrated in Eastern State, as we saw in the coverage in the May Free Press article, or is it present in many of our hospital censuses?
It's present in many of the hospital censuses. Of course, Eastern State has a large population of forensic patients, but many of our hospitals, you can at any time, it's approximately 40% of the state hospital census is forensic.
Follow-up question, and how much has that grown since 2017 or in the last 4 or 5 years?
I don't have an exact number of how much it has grown, but it has been growing over the last several years and will likely continue to grow.
If I could ask for a follow-up so that we have a statewide context, if you could show the growth, at least since 2017, in each of our state hospitals, so that we have some idea of how this is adding to our bed shortage.
Of course. Okay. So 2 areas that I will provide some suggestions on for our forensic patients are court-ordered evaluations, ensuring that we have high-quality evaluators available and requiring second opinions when appropriate, and also streamlining hearings, which includes expediting competency to stand trial hearings and remote testimony. So I'm going to go into detail about those suggestions in the following slides.
And before we go on to that, because I'm not sure that that would be covered, in addition, on my request, to the degree that you can track it, the proportion that are there on misdemeanor charges and being evaluated, and those that are being evaluated on felony charges.
I will get that information to you as soon as possible.
Thank you.
So the next slide, courts sometimes have difficulty locating evaluators that can conduct the evaluations. This is usually more of an issue in rural areas, but when there is a difficulty, sometimes that results in the order becoming an inpatient evaluation, or it can result in a delay in the process. Currently, the code governs the compensation of experts who conduct these evaluations, and the fee cannot exceed $750. And that $750 amount is for a combined competency and sanity evaluation. The competency is $400 when ordered separately, and sanity is $500. The last time the rate was increased was in 2007, and currently Virginia rates are well below the national average. We believe that increasing the compensation for the experts providing these evaluations will help us to retain qualified evaluators and to get more qualified evaluators that are available.
Thank you.
Next slide. With our insanity evaluations, they're ordered when the defense is going to explore the possibility of an insanity defense. The evaluation determines whether the individual was insane at the time of the crime and whether they can use that defense. About 65% of the acquittees are committed after the temporary custody period. And once they are committed, the average length of stay is about 5.5 years. Currently, a second opinion evaluation can be ordered at the discretion of the Commonwealth, but this rarely happens. In a study that we did in 2017 with the ILPPP, there was a study of 188 evaluations requested by the defense that led to an opinion of insanity. And a second opinion was only requested in 16% of those cases. When there was a second opinion, 47% resulted in an opinion of insanity, therefore agreement between the two evaluators, which means the other half, there was disagreement. We believe requiring a second opinion insanity evaluation when the defense proceeds with the insanity defense could result in a reduction of insanity acquittals, which could impact the state hospital census greatly. While we support the insanity defense, we believe improving the process will ensure our limited resources are being used for the appropriate population. So this does not request that the that the second opinion is required for all insanity evaluations that are ordered, but only the ones where the defense is going to move forward with that defense. We very much support the insanity defense. We just want to make sure that it's being used appropriately and that our limited resources are being used for those that it's most appropriate for.
May clarify. Go ahead, Senator Mason. My clarification is a second opinion was requested in only 16% of the cases. What are the limits on making such a request, and where does your requiring a second opinion fit into that such a request situation?
There are none. The Commonwealth can request that. It just doesn't happen very often that they do require it. And so we're just suggesting that perhaps that it can be a requirement. So anytime a defense is going to move forward with the insanity defense, then at that point, a second opinion would be required.
Madam Chair.
Yes. I'm sorry. Oh, Senator Deeds. Yes.
Yeah. Ms. Shine, isn't it fair to say that the insanity defense in Virginia is really, the standard is very high, and there probably aren't a lot of requests for second opinions from the Commonwealth because there aren't a lot of insanity findings by evaluators. The insanity findings that are reached in Virginia courts are primarily the result of agreements by the Commonwealth and defense. Isn't that pretty much the case?
The bar is high, certainly, for the insanity, and there are not a lot, but we had 51 temporary custody, or we had 51 inpatient and 20 outpatient temporary custody evaluations this year. So it's not, it's a significant number. And if there was not agreement on them and that person maybe wasn't the most appropriate, then that person ends up being in our system for a long time, using resources that perhaps that person could have been diverted in a different way.
Senator Deeds?
No, that's fine. Thank you.
Madam Chair.
Yes, Senator Mason.
Yes, ma'am. Thank you. As Senator Deeds said, because the bar is so high, that might keep the number down. But has your office done any work on evaluating the areas that these NGRI cases come from, regions, court specific, or areas? Have we looked at any information like that?
Yes. Region 5 does have a very high proportion of NGRIs. Eastern State Hospital has the largest number of NGRI equities in the state. I don't know.
And I mean,
go ahead.
Sorry, Madam Chair, one follow-up.
Please.
And so, yes, ma'am. Of course, that's of interest to me. When I was last at Eastern State, 32%, 94 out of 302 beds were NGRI, which is, of course, an important defense and a justified one. But it's when we begin evaluating the 6-year bed that it generally takes is something we ought to look at. So I meant, have we drilled down any further? So yes, Region 5 is big. Are there specific courts, specific areas, specific regions within Region 5 that we've done just an evaluation on the numbers as they come out?
We have data on all of that, but we haven't been able to find a specific cause for that. We implemented a few years ago the evaluator management system where all evaluators had to submit redacted copies of their evaluations and to ensure that they were meeting the qualifications, and they had to have requisite training and experience. And we were hoping that would reduce some of the evaluators that perhaps weren't operating at the proper level. And while that did reduce some of the evaluators that weren't maybe doing a great job, it still didn't quite reduce the number of acquittees that we saw in that region or any region. And so we've tried a few different things over the years, and we have not been able to work on exactly what is causing that problem specifically in that region. We are putting together a work group as we speak to look at restoration and diversion options, including we'll have people from representation from the CSBs, state hospitals, the court system, and advocacy groups to look at some things that we can do specifically to work on those types of admissions to our facilities. And hopefully we'll have some recommendations out of that work group.
A couple of follow-ups. So that this work group that you've described has the full participation of the Secretary of the Supreme Court?
We are just putting together, in the very early stages of putting together, the participants that will be inviting to the group, but certainly will include OES.
The reason for phrasing my question that way, my assumption is that they have case data so that you could have some sort of a measure of percent of felony charges or percent of certain type of felony charges, let's say for the sake of discussion, violent felony charges that are coming out of each court, so that we can perhaps analyze the use of the defense based on the initiation of a motion, as well as what you're doing on whether there's a difference in evaluation on the NGRI.
Certainly.
And again, I would hope, I'm being a statistics person, I would really hope for that kind of a understanding of the use of it. Again, not out of the concern that a defendant shouldn't be properly regarded, but making sure that this indeterminate sentence also isn't inappropriately applied to an individual who might be more justly treated in a different way.
Yes, there will be a focus on misdemeanor charges and how to best deal with those individuals.
I was thinking all of this was your work group. I'm assuming, if I'm wrong, I'd be very interested in that NGRIs are applied to felonies rather than there wouldn't be a misdemeanor charge that would warrant such a determination. There are charges, misdemeanor charges, that will get an NGRI, but there is a time limit of 1 year for those individuals that have a misdemeanor NGRI versus a felony. Thank you.
Moving on to competency to stand trial. Those evaluations are ordered to assess the mental status, the current mental status, and how it impacts their individual's understanding of the legal proceedings and their ability to assist their defense attorney. Often there's a lengthy delay between when the evaluation is completed and when the matter is decided in court. Delayed hearings can result in stale opinions, and the mental health status of an individual can change over the course of weeks, which can lead to the need for an additional evaluation, a delay in the court case, or even a readmission for further evaluation and services. Unfortunately, it's not uncommon for individuals to enter a revolving door between jail and DBHDS to address mental status decline while they're waiting in jail for their hearing. And this is disruptive to their continuity of care. It's resource intensive and can cause admissions that are unnecessary, which impact the state hospital census. Our request would be to add language in the code similar to that and the NGRI code, which asks to expedite competency to stand trial hearings.
Questions?
Madam Chair.
Yes, Senator Mason.
So particularly on this slide, I'm a little surprised to hear at the end of the last one that there are NGRI cases for misdemeanors. That's interesting. But this competency to stand trial particularly, do you have a breakdown of misdemeanor versus felony here?
I You want the breakdown of how many individuals get a competency to stand trial evaluation for misdemeanor charges?
Yes, ma'am. What percentage of these are misdemeanors?
I don't have that information off the top, but I can certainly get that to you very quickly.
Because, that is an interest. There's so many out, Madam Chair, excuse me.
Yes, please proceed.
There are so many directions to go with that question. One, it costs us an average of $890 a day in a state-run mental facility. If you're averaging 52 days to get the competency to stand trial done, that's $50,000 for a case that could be petty larceny, could be trespass, minor crimes. And so, I know at least, in my backyard, of course, of the restoration cases, between 35 and 40% of them over the last 3 years are for misdemeanors. And so I'm interested in your thoughts on that. Certainly this competency crisis in the nation has been an issue for years. What's your position on that, or what's your evaluation of that, or just what have we been thinking from the review of misdemeanors in these competency to stand trial questions?
That's certainly one of the focuses of the work group that we are putting together, is how to manage the misdemeanor restoration for petty larceny and trespassing and disorderly conduct. There is a 45-day limit for restoration on those three charges alone. And then the other misdemeanors have a longer period of time, and the average length of stay is longer than that 45-day period, as you mentioned, for restoration, typically in an inpatient setting.
Senator Deeds, did you have a question?
The only point I was going to make is that there are a whole lot of people with misdemeanor charges also have felony charges. And I hope that when you break the numbers out, you separate those people who are just misdemeanors, are just charged with misdemeanors.
Yes.
So that we don't have any mixed metaphors, because people charged with felonies are in a different category.
Thank you for that clarification. Delegate Bell.
Yeah, actually, Senator Deeds beat me to this, which would be, I only have my own observations, but at some point you get enough observations, they become something approaching data. I would say to the non-lawyers, boy, we don't see a lot of this for misdemeanors. And when I say a lot, I cannot recall one for misdemeanor in 25 years, not just my cases, but any case I've ever observed in court, which is in the tens of thousands at this point. I'm not saying it doesn't happen. It may be outside the area, but I suspect what Senator Deeds identified, which would be where there are misdemeanors, they are alongside a felony case. Just otherwise, at least in my experience, the prosecutors find a way to not have that happen, and or the defendant doesn't ask for it because the outcome of a lengthy observation is worse than just doing the case from his perspective. Question on that point.
Yes.
Do you have to be incarcerated while this is happening? In other words, because again, misdemeanors are more commonly released on bond or even their PR bond. And so while there would be restoration processes, it wouldn't include the 3 hots and a cot and inpatient and all that goes with that, unless I'm mistaken. And I guess that's the question.
No, you're correct. There is an outpatient evaluation and restoration process available, and outpatient includes the jail and in the community. So if the person's out on bond, then the CSB can provide the restoration services in the community. Or if the judge does not want to put them on bond, then the CSB can provide that service in the jail and avoid sending them to the state hospital for restoration services when it's not necessary.
Madam Chair, I guess I would then just second the request for breakdowns of the data would be helpful, I think, when we have to make some policy decisions. Thank you.
Certainly, as I have listened to all of the questions, I have that absolute need for clarity, so that the perspective of having someone who's just on a misdemeanor charge in a hospital bed needs to be clarified, and then the degree to which community services provide the evaluation versus the state hospital. But I would also add, given the practice areas of the senator and the delegate, that we make sure that we're looking at the degree to which this occurs in various regions of the state, so that we're also then informed. At one point in looking at this issue, I was thinking in terms of, this is exactly what some of the crisis intervention and diversion issues have all led towards, is getting people into the proper treatment at each point in the diversion. And so there may be areas of the state that are further along in diversion, which is causing then this hospital bed population issue. But all of that we need to know to properly anticipate where this kind of treatment and evaluation services are best provided if we have more diversions, as we all would hope that there are appropriate diversions at each point. Yes,
Madam. Oh, excuse me.
Senator Mason, Deeds first.
I just want to follow up. I understand Senator Mason's concerns, because there's something going on in Hampton Roads that doesn't go on anywhere else. I've practiced law for almost 37 years. I've never seen a case where an evaluation is done on one who's charged only with a misdemeanor. Let me give you a case I've got currently that's somewhat of an example. I have a guy charged with felony possession of large amounts of some kind of narcotic, but also some misdemeanors, obstruction of justice, and assault and battery. They're somewhat related. He couldn't communicate with me effectively what happened. His thoughts were so disjointed, and his family told me about some mental health, some diagnoses he'd had in the past. I had him evaluated. And he was determined to be not competent to stand trial. But he was evaluated while he was outside on bond. His bond was revoked because the psychologist recommended he receive inpatient treatment, and now he's in a state hospital. But while they're trying to get him restored, get him in a position where they can try the case, we can try the case. But that's a person who's got a misdemeanor. Got multiple misdemeanor charges, but also a felony. And those kind of cases, just as Delegate Bell pointed out, they need to be separated from the pure misdemeanor cases.
Thank you. Senator Mason.
Yes, ma'am, Madam Chair. And the reason, as the non-lawyer in the family, I'm always super careful and listen to what Senator Deeds and Delegate Bell says. The data for the last 3 years at Eastern State is broken out in such a manner. So as I mentioned, the 35 to 39% of the restoration cases in the last 3 years are misdemeanor charges only. Felony charges only are 28 to 36%. And then the ones that are difficult to determine are the misdemeanor and the felonies. In 1 year, there were 31% of those, but it also includes the assault and battery on the law enforcement officer, which may have been a portion of the mental crisis or breakdown. So that is exactly why it was so concerning and alarming to me, in that dominant high percentage, 126 out of 355, 102 out of 313, 98 out of 281 through May of this year are misdemeanor only, being sent for competency hearing to stand trial. So I think it is an important point, and one of the reasons that it alarmed me so greatly. So thank you, Madam Chair.
Thank you, Senator Mason. And that's, again, excellent focus to bring this all to our attention. And I'm going to add a very small point in reading some of the issues involved. Very small point is the necessity to do physical modifications to state hospitals because of the violence that may be present in someone who is in crisis, such that they're acting out violently and therefore much more apt to be on a felony charge. And that separation also helps us focus on what type of services and facilities we need to really plan for as we look at appropriate diversion. Okay, I don't see any more questions. Please proceed, and thank you for taking this format and allowing us to discuss each one of these.
Of course, and I'm making notes on some additional data points so I can provide that for you after the meeting. And our last slide is on NGRI hearings and remote testimony. During the 2020 General Assembly session, we worked with Delegate Hurst on House Bill 639 to allow for remote testimony for NGRI hearings for the annual review hearings in person. Attendance is still required for the initial commitment, the petition for conditional release, and the revocation of conditional release. The court maintains the discretion to grant the request for remote testimony or to require in-person attendance. Remote testimony is helpful to relieve the stress on law enforcement who are required to transport quitties to their hearings, which are sometimes far away. Remote testimony also is beneficial to the state hospital staff who are subpoenaed to attend. It takes them away from the hospital for long periods of time. And finally, most importantly, remote testimony eliminates the stress of travel and possible time in jail waiting for court for psychiatrically fragile defendants. And during the COVID-19 pandemic, most court hearings were done remotely and found to be a viable option. So we would like to see if we can put that request in to have all of the NGRI hearings. So that would include the 0.3 initial commitment, the 0.6 petition for conditional release, and the 0.8 revocation of conditional release to all be able to occur remotely as well. And the court would still maintain the discretion to grant the request for remote testimony or to require the person to attend the hearing, both the equity and the expert.
Thank you. Comment, questions? Looking at both this and several of your other slides, you had specific recommendations. Senator Deeds, looking for your guidance, I'm assuming then we need to tease out each one of these specific recommendations and bring it before this subcommittee at a subsequent meeting as to what our recommendation would be to the full committee. Is that part of the agenda?
And Madam Chair, you can run your work group as you choose, but that would certainly be that would be great if you would provide as much recommendation as you can about the various ideas that are presented in these presentations.
Thank you for your always valuable guidance. I feel much better in my role. In addition to that, I just am clarifying, because this is a public meeting, your presentation as a slide, downloadable slides, will be available on the LIS website. I am getting the nod that yes, this is true. So both for members as well as the public, there's a lot of information in these slides, and that is a way for you to obtain it accurately. Are there other comments or questions? Okay, so I know a number of people have a rather short time frame for this meeting. On the agenda, the next item is public comment. I am just going to say, prior to public comment, at this point, what we have is, again, the McClellan and Bourne legislation will be back before us. Senator Deeds will do the best he can as far as the appropriateness of the 24/7 online mental health being part of the American Rescue Act funding, any aspect thereof that puts this into place, particularly for school-age population. Then we will look at each of the recommendations that are within the slides, as well as have a follow-up presentation with a number of the requests for statistics and follow-up questions that you all have brought up in the last agenda item. And that then is at this point what we're going forward with. And so it is now, is there anything that I have missed thus far? Then we will open it up to public comment. Do we have people in the waiting room?
Madam Chair, we do have several people in the waiting room. What I would do now is ask that anybody who is desiring to speak to raise your hand electronically, and I will bring you into the room. And currently we have one panel or one person with their hand raised. That is Anna Mendez. We also have Bruce Cruiser who can speak after her, but we have, I believe I brought her into the room.
Ms. Mendez?
Good morning, Chairman Watts. Can you hear me well?
You can. Mm-hmm.
Thank you. Thank you. My name is Anna Mendez. I'm the Executive Director of Partner for Mental Health in Charlottesville. I'm grateful to be here with you today. I would like kind of to answer one of your questions, Delegate Watts. We at Partner for Mental Health, we have scraped, I believe is the official technical term. We have scraped the publicly available court data in Virginia, and I would like to support what Senator Mason is saying. We have found that approximately 25% of criminal defendants who are facing competency restoration are doing so for misdemeanor charges alone. We do not have visibility into whether or not that is happening within the state psychiatric hospital setting or whether that's happening in the community. But we are finding that across the state, it is approximately 25% for misdemeanor charges alone, and more than half of the competency evaluations are happening for nonviolent charges, whether they are felonies or misdemeanors. I would also want to bring a bit of perspective to the conversation around our NGRI equity population and remind this subcommittee that only approximately 30 to 40 people a year are adjudicated not guilty by reason of insanity in Virginia. So 30 to 40 of every single criminal defendant in Virginia is ever found NGRI in Virginia in a year. And we have also scraped this data as well. And of course, Senator Deeds is correct. The vast majority of the time, there is not a trial. The Commonwealth agrees with the assessment of NGRI. What we see as community practitioners is not actually that people who should not have been adjudicated NGRI are ending up being adjudicated as NGRI. We are actually seeing kind of the opposite problem, which is that someone who quite clearly has a strong case to make that they could in fact be found NGRI is not interested in pleading that way because they are intimidated by the idea of a indeterminate sentence and because of the prejudice and discrimination that people still face when they publicly disclose that they have a serious mental illness. In terms of mental health dockets, I would, and I know that some of you know that I serve on the Charlottesville-Albemarle Advisory Board to our therapeutic docket, but I am only speaking want to be clear, I am only speaking on behalf of Partner for Mental Health today. I encourage this work group to remember that there are only 14 of these dockets across the state. And they are incredibly effective. So as we are looking towards potential opportunities to address both our hospital bed crisis and the fact that we do not want defendants with mental illness in jail, because people do not get better in jail, they get worse in jail. Expanding access to mental health dockets across the state would be a really strong step in the right direction. We would also encourage this work group, kind of going back to competency evaluations, At Partner for Mental Health, we believe that there has to be a better solution, at least for people with misdemeanor charges, that protects their constitutional rights, that facilitates meaningful access and prompt access to clinical treatment and maintains public safety. Professor Bunny has proposed such a novel solution that's currently in press right now in the Journal of the American Academy of Psychiatry and Law. And I am going to send a copy of that paper to the work group for your consideration. Thank you very much.
Thank you. Are there questions of Ms. Mendez? Thank you, as always. Is there someone else in the waiting room who wishes to share with us?
Madam Chair, we have Bruce Cruiser, followed by Edmund Creekmore.
Thank you. Mr. Cruiser.
Yes, thank you, Delegate Watson and members of the work group. I'm Bruce Cruiser, Executive Director of Mental Health America of Virginia. And first commend you for what you're doing in terms of making sure that the criminal justice system remains a priority in terms of the whole issue of mental health. And but encourage you to also get an update at some point from the Board of Local and Regional Jails. You know, they have a full-time executive director now, Mr. Ryan McCord, and they have been reviewing the deaths of inmates as a result of work by this joint legislative subcommittee a few years ago. And they've recently recommended decertification of the Hampton Roads Regional Jail due to the recurring issues there of inmate deaths and the blatant disregard for standards. And then at the same time, they've also recommended, or at least their jail subcommittee has recommended decertification of the Riverside Regional Jail. And working its way at some point through the administrative process are the proposed new minimum standards, which also the legislature passed a few years ago. But those are, my understanding is those are still not in effect. These are minimum standards for mental health care in local and regional jails. And they have a set of standards was approved by the Board of Corrections, and they're now going through the administrative process for comment. I'm not exactly sure where they are in the process, but I thought it might be helpful for the legislature to have an update on the work of that board and also those minimum proposed standards. And if there is a time, perhaps in your meetings, maybe at least staff could get information to share with the members, because I think it's important that we keep eyes on this process. So thank you very much.
Thank you for sharing that information. Any questions? Thank you. We will follow up. Mr. Creekmore. Mr. Creekmore, you're on. Mr. Jackson, is Mr. Creekmore still in the room?
Madam Chair, he is still in the room. Mr. Creekmore, if you're available, please unmute yourself and go ahead.
Can you hear me?
We can. Thank you.
Yes. Yes, I would like to begin by thanking the Watts Committee for this opportunity to address the committee members. I'm a licensed clinical psychologist and independent examiner for the state's Supreme Court. I do evaluations, independent assessments for TDO hearings at a major Central Virginia hospital. I'm affiliated with a major practice in the Central Virginia area, working with psychiatrists and mental health professionals. I have a background in youth and adult corrections, and I do assessments for a long-term residential facility in Goochland. I am very interested in the special populations agenda. We took particular interest in the discussions and some of the data shared by DBHS about criminal mental health dockets. I've reviewed some of the inaugural meeting, Chairman Watts, in which data was provided about the effectiveness of the mental health criminal dockets. I would like to see, and I have proposed in writing, and I do have a statement that's rather lengthy, and I don't want to take up too much time of the committee, but it is available, that describes in detail some of the proposals that I have made for revising the MOT code, which is one of 4 options that the special justice has before him. Just to review, those 4 options are dismissal if the patient does not meet commitment criteria. That doesn't mean, by the way, they don't need the help and shouldn't be referred for intensive outpatient services, but they don't always meet the criteria. The other options are voluntary admission if they do meet criteria, and medical necessity criteria, also involuntary commitment, primarily for patients who are at risk for self, and others are so substantially impaired in their decisional capacity and ability to protect themselves and care for themselves that they require inpatient care. And the 4th option, and the one that is of greatest interest, I think, to the HOPE committee as well as your own committee, Chairman Watts, is the MOT. I believe that we are underutilizing in the entire system. If we're serious about wanting to decrease the populations of the state hospitals, crisis stabilization units, and even, in fact, I think community-based services, we need to find a more effective way of leveraging the substantial contribution of families in this process. The families are the final resource, shall we say, to many of these patients that we're talking about, whether they are in the criminal system, usually on misdemeanor charges, sometimes felonies, but typically misdemeanor, and that come to the attention of the criminal dockets. The research suggests that these criminal dockets are evidence-based, they're cost-effective. I'm not so sure that to what extent they involve the families, but I think there's a unique opportunity here through the restructuring 37.2817, and I've described my proposal for doing that, to involve the families in what is sometimes referred to in the literature as therapeutic jurisprudence, using the court system therapeutically to get some of these very difficult SMIs, serious mental illness patients, and their families involved in a therapeutic process. That unfortunately begins oftentimes with a TDO in the civil hospital. Sometimes it begins with a magistrate, a competency evaluation in the jail system. However, the current version of 37.2817 does allow, as I am understanding it, some limited involvement by families, both at the initial TDO hearing and at the follow-up review and status hearings. This is a way, if I am understanding HIPAA law, I think many of us recall what happened in the April 20th meeting when Stephanie Williams made a very moving presentation about what happened to her loved one who'd been in and out of the Allegheny system hospital up there. diagnosed with bipolar disorder with psychosis, unceremoniously discharged. Family didn't know where he was. He was even transferred to Eastern State Hospital. Same story. He was discharged. They didn't know where he was. He was homeless, wandering the streets of Petersburg, Newport News, wherever he may have been. The problem is these artificial barriers, seemingly legal barriers with the privacy laws and a difficult to understand state and federal laws generally, but particularly this MOT law that is difficult to understand. Even the judges, the attorneys, people like me have difficulty at times understanding them, being able to apply them. I think if we can find a way through changes in statutory law to revise the MOT law, then we can use it effectively as a civil version of a mental health docket. This would be a novel, innovative way of addressing this issue. To my knowledge, there are no other states that are actually using mental health dockets, cost-effective and evidence-based as they are with this type of population. As Senator Mason said, very often we're dealing with one and the same population. It's just a question that often seems a bit arbitrary. Maybe it's not so arbitrary as it seems, but whether they end up with the magistrate sending them to the jail for a misdemeanor, or whether the misdemeanor is waived and they're sent to the ER for on an ECO or a TDO. The way in which the code could be revised, I'm going to keep my comments brief. Please consider Adams House Bill 1026, that the portion of that bill that would do away with the requirement that there be a 3-year, rather arbitrary period of time in which, if there are at least 2 hospitalizations or commitments, I guess, to other CSUs or what have you, to allow the judge to be able to hear and have the option of the 4th option, that is, of the MOT available on initial presentation. I also am recommending that the judge be given the discretion to order a voluntary with consent or involuntary without consent order to involve. This would allow, as I'm understanding HIPAA privacy laws, would allow some limited participation at the discretion of the judge for the families to come in. They already do come in to some extent, but where the expectation is, as part of a civil MOT docket.
Mr. Creekmore, if you could wrap up.
Okay, yes, all right, I will. So anyway, I think extending the 72-hour period to 96 hours gives the independent evaluator and the psychiatrist more time to do a competency evaluation, which in many, well, not a capacity assessment, only the judge can rule on competency, but that's entirely too little time. Those are the 3 proposals for revising the MOT. I think step down after the goal would be to dismiss appropriate level of care under the special justice supervision, to dismiss the voluntary order, step down to community-based care using some models such as supported decision-making, shared decision-making, and New York State uses something.
Mr. Creekmore, I thank you very much. What I'm going to do, you have covered these points, I think, also very well in emails that I've appreciated having, and I'm going to make sure that all of the members of this subcommittee receive the chain of emails that you have initiated, as well as Professor Bonnie's response to it. I will be talking with Delegate Hope, as well as, of course, Senator Deeds, to see just which subcommittee needs to stay focused on this. I think that much of it is going to be the purview of the Hope subcommittee, possibly Senator Mason's. I'm just not sure how it fits in, except you're absolutely right that all of this affects the focus of this special populations subcommittee as to who actually ends up in jail, in law enforcement, and all of those appropriate points of diversion and appropriate treatment. So thank you very much, and I will make sure that this material is shared.
And thank you very much. I appreciate your consideration of my ideas and proposals.
So as is there anyone else, Mr. Jackson, in the room?
Madam Chair, that was the last speaker.
So that in addition to what I had referred to as far as looking at the McClellan and Bourne legislation and following up on all of the questions and focus of the forensic services assessments. Also, we will slot at some point a brief update on the jail standards. And also I want to mention that this committee at some point, I'm not still sure what's on our purview for the upcoming session, but certainly children's populations are another part of the special populations definition, not just the law enforcement side, as well as we have frequently heard from the commissioner the issue of geriatric beds, particularly Alzheimer's and dementia patients that are in our state hospitals, and whether or not we should have a different focus on meeting the needs of these individuals who can't be handled in private nursing homes. Are there other comments about things we need to be bringing up so that we're ready for the upcoming session?
Madam Chair?
Yes, Delegate Bell.
When you say the upcoming session, do you mean the special session we now understand to be August?
As I understand it, the focus of the special session is just the Rescue Act, and there the focus is on, at least from today's meeting, is the 24/7 mental health counseling availability or hotline availability, particularly for school age.
It's clear in your thinking and probably clear to everybody but me, but so what you're talking about would be things we would take up, not necessarily in the next few weeks in July, but over the course of the
2022 session. Yes, thank you for the clarification. Thank you. No sidebars.
Just got to tear up our calendar and get to work. Thank you.
All right. Any other clarifications, comments? If not, again, I thank you all for your attendance and the perspective that you have brought. Thank you very, very much, particularly Senator Mason. I'm so glad you were able to join us. As always, Delegate Bell and Senator Deeds, to make sure we have a broad perspective. And Sia, I'm going to talk to you offline and just find out what you're thinking. Thank you so much for joining.
Thank you, Madam Chair.
Thank you. Have a good day.
You do the same.
Thank you, Sabrina.